Good morning. I'd like to call the Physician Assistant Board meeting to order. This morning is August 10th. We are meeting at the Sheraton Hotel in San Diego. The time is 8:30. Rosanna, will you please call the roll?
Good morning. Charles Alexander,
Present.
Juan Armenta,
Present.
Jennifer Carlquist,
Present.
Sonia Early,
Present.
Javier Escobar Acosta,
Present.
Jed Grant,
Present.
Xavier Martinez,
Here.
Robert Sachs,
Present.
Mary Valencia. Here.
Okay, we have a quorum. Next item will be approval of the April 23rd meeting minutes. Do I have a motion to accept?
I'll make the motion.
Second.
Further discussion? Rosanna, will you call the roll, please?
Charles Alexander,
Aye.
Juan Armenta,
Since I was not here, I'll abstain.
Jennifer Carlquist,
Aye.
Sonia Early,
Aye.
Javier Escobar Acosta,
Aye.
Jed Grant,
Aye.
Xavier Martinez,
Aye.
Robert Sachs,
Aye.
Mary Valencia. Aye.
Okay, the minutes are passed. Next item, update regarding optimal team practice. I would like to comment that this is moving forward. There have been multiple meetings at this conference by CAPA. Jed was able to attend some of them yesterday. Jed, do you want to comment a little bit on that?
Sure. Always happy to comment, Bob. So, optimal team practice is basically a way to maximize the effectiveness of the PA physician team, and basically it represents an update to our practice laws to sort of maximize the effectiveness of what we're doing and have real representation legally of what's happening between the physician and the PA and with patients in practice. So, in a very brief answer, that's what it is.
Okay, thank you. I'm going to skip item 5. Oh, yes, public comment. Okay, there being none, I'm going to skip item 5, go to reports. President's report. I just wanted to report briefly, we had a very good meeting with DCA Financial Budget Office individuals. It consisted of Lynn, Xavier, and myself, and Wilbert and Marie. It was very enlightening. We found out things in the budget documents, what some of the categories were, which I was unaware of. So it was a very good meeting. I will defer the rest of the report on budget to Xavier later on in the meeting. Second thing is we have a new board member with us this morning, and he is Juan Armenta joining us. He is a public member appointed by the Assembly. Would you like to say a few words?
Sure, I hadn't planned on it, but I'd be happy to. The speaker was kind enough to appoint me. I've been practicing law for 28 years now in Rancho Mirage primarily. Initially started with insurance defense work, and now my primary practice in terms of file volume is workers' compensation. So I have a great degree of interaction with doctors and physicians' assistants. So when the speaker asked me, I thought that was a good opportunity to, now that we're empty nesters, give back a little bit to the public community. And I think the additional perspective that we see, the overlap of legal to PAs, I think would be useful to the board. So it's my pleasure to serve our state.
Thank you. We're very happy to have you on board with us.
Thank you, sir.
That concludes my report. Let's go to Executive Officer report. Lynn?
Good morning, everybody. Just a very brief update on our lease for the Evergreen building. It is moving forward. We are going to sign a 4-year hard, 4-year soft lease. We will be remaining. The upgrades are going to be done, but the big news is DGS, has informed us that in March of 2024, we will be moving to a brand new campus which will encompass all of DCA. So we're very excited about what's happening. We will also be moving our office, we hope within this year, upstairs to a larger facility because we have literally outgrown where we're at. And that's the end of my report.
Okay. Further discussion by the board members? Public comment? Okay. The remainder of the reports are in the packets and on the website, so we will defer C, D, and E. Let's go to item number 7, Department of Consumer Affairs Director's Update.
The DCA executive staff provided an update that we passed out this morning, and it just gives you a brief idea of what DCA exec has been up to.
Yeah.
Okay. Oh,
Okay. Well, that's exciting news. We definitely need a larger facility than what we're in now. The file room is packed, and there's little or no room to move around. Plus, it is somewhat unsafe as there is only one entrance and exit should there be any kind of a fire or problem. So I'm happy to hear that we'll be moving upstairs, and that's good. So, all right, public comment? Okay, there being none, we're moved.
we have a board member.
Board member comment.
Question, they comment on the update on fiscal, but they really don't give a date or anything, they're just working on it still?
They're just working on it still. As we were made aware this week, we have month 11, so they're still trying to get everything finalized, and there's still some issues, but they're trying to get them worked out.
Okay, thank you.
One, for your information, Fiscal is a new program that Department of Finance and Budget put in about a year ago. And it's pretty much been a nightmare. We have not had a financial report since it went into existence. So we're living with very little information on what our finances are. One of the nightmares with our board is that we're not allowed to be in the red at the end of the year, and we really have no idea where we are. They keep assuring us that we're okay, but there's no accurate documentation of that. And it's not just our board, it's the entire Department of Consumer Affairs.
So this program is, fiscal is just for the Department of Consumer Affairs or
No,
statewide?
statewide.
The entire
State.
state.
Oh, wow, okay, well,
Yeah.
that's not good news, all right.
No, their first year has not been stellar.
All right.
At this time, I would like to move back to item 5, public comment not on items not on the agenda. Please note the board may not discuss or take action on any matters raised during this public comment section that is not included on this agenda, except to decide whether to place the matter on the agenda for a future meeting. Is there any public comment?
Good morning.
Good morning.
I'm Jeremy Adler, Chair of the Task Force on Optimal Team Practice with the California Academy of PAs, and I appreciate the opportunity to share with you a little bit about what it is we're up to these days. CAPA representing the PAs here in California, where we have over 11,500, as you know, is a time of change here in our profession. Last year, you had a presentation from the National American Academy of PAs talking about the Optimal Team Practice initiative nationally. And to review that initiative, this is the kind of global movement here in the PA profession, and that is that we seek to continue to have an important relationship between team practice. Physicians, PAs are optimally suited to practice together, and that intends to continue in terms of OTP. We also want to see the relationship, though, transitioned. And presently, as you know, PAs in California have a delegation of services agreement with a specific physician. Here in California, we have been looking at that relationship, and really what we'd like to do is transition the regulation of our profession from the PA physician supervisory relationship to focus on the patient themselves. That we feel that standards of care, that the patients are really the kind of product that the team produces, and we want to empower that team as healthcare transitions into kind of the anticipated future, which is a large systems-based healthcare system. We need to have PAs optimally integrate into that system. We also want to look at how PAs are reimbursed. We are the only healthcare profession that's not directly reimbursed that provides care. We need to look at that. That's being done nationally. And certainly here in the state, we want to ensure there are no barriers to reimbursement of PAs. We also want to make sure that our board is empowered. All of you are vitally important in terms of regulating our profession. We absolutely recognize the importance of having a strong regulatory board, especially with this change. One of the things that we're specifically looking at is removing the concept of supervision with PAs and move to a collaborative relationship. We've been talking with the physician groups and others as to how that might look, but the idea is to move things to the practice level. Excuse me. We're not looking to eliminate relationships. I mean, we're not looking to have PAs practicing in a silo by themselves and independently taking care of patients. We're looking to ease the ability for teams to be innovative, be effective, and really increase access to care here in California. In terms of what that means mechanically, as a regulatory board, we're looking at things like the DSA, the protocols, formulary, and we're looking at these things as not having them exist really in this model and moving that to the practice level where teams can decide the best way to utilize their healthcare professionals. So I think that's really where CAPA is going. We're looking at introducing next year a bill. We hope the PAB is supportive of our efforts and that they continue to do the work that you do. And really you are a key part of the balancing measures here as we approach trying to improve the PA practice here in California.
Okay.
Can I
Thank
ask
you
a
very
question?
much for that update. This will obviously be on our next agenda, and at that time, we would take comments from the board. Is there any other public comment? President Sobol, do you want to speak for a couple of minutes? He is president of the American Academy of Physician Assistants, who is here today. Okay. Thank you very much. That will close public comment. We will go to agenda item number 8, report of the Medical Board of California activities. And I believe
It's just the update on the route. She didn't write anything. There now. Locating position.
Okay. Obviously, Kim Kirchmeyer was unable to attend here because we're meeting in San Diego. Probably one of the single biggest things that has occurred in the last couple of weeks is the Medical Board of California has created an application that works on iPhones, which allows you to download the app and go in and you can look up any physician, very similar to what you do by going into the Medical Board website, but it's portable, it's on your iPhone. And we are attempting to see if we can also participate in that, and we are negotiating with the Medical Board at this time so that the PA licensees would also be included in that information. And that concludes the Medical Board report. Public comment? Okay. We're flying this morning. Yeah. We're moved to item 11, discussion and possible action regarding development of proposed regulations to implement waivers of renewal requirements for members of the United States Armed Forces or California National Guard who are called to active duty. Would you like to go first?
I
Or
think
Anita?
Ms. Winslow might want to present on this and be happy
Okay.
to chime in if she needs me to.
Yeah.
Okay.
So we discussed this at our last meeting. I had a meeting with Jed and Lynn between these two meetings to discuss what would be effective. And we found that we've come into a little bit of a snag because there is nowhere in the statute that defines what they mean by active duty military or called to active duty. So we do have armed force personnel that's their job, and there's nothing that defines what it means because they're always active duty. So we have nothing that defines what the statute means as a call to active duty. So we're trying to decide if we should avoid defining that within the regulation.
Okay, so
Thank
just to refresh your recollection, because it's been a few months, a law was enacted a few years ago, Business and Professions Code Section 114.3. That enabled the boards in the department to waive the renewal requirements for those persons called to active duty who are in the U.S. Armed Forces or the National Guard. So the problem has been, if you look at the attached Senate Rules Committee analyses, it says that the revisions to the bill, because originally it used to say in the bill, United States Reserve or National Guard. But then at the last minute, the Senate struck that and replaced it with United States Armed Forces. So there was obviously intent to expand the scope. It says under Senate floor amendments, expand the scope of the bill to apply to all members of the U.S. Armed Forces. So the original intent of the bill was to waive temporarily the requirements, which would include the fee, filling out the application, meeting continuing education requirements, so that people who were called to active duty unexpectedly wouldn't be burdened with having to worry about renewing their licenses. So that's pretty straightforward when we're talking about reservists who were civilians and then called to active duty. Same thing with National Guard. But how do you define it for someone that's already on active duty, that's an active duty career military person? And how do you define it, the limited circumstances where they would have difficulty renewing their licenses because perhaps they're in a combat deployment? I don't know. I'm not a military person, so I wouldn't say that I'm well versed in all the various circumstances. So we've had a really difficult time trying to clarify that, because with a statute, you can be quite general. But when you're adopting a regulation, one of the requirements is for clarity. And I'm having a hard time defining the scope of who this waiver could be applied to. So any ideas the board members might have on how to deal with this, perhaps we just have the application and not really clarify it. I don't know if any of you have any ideas, and I've spoken to Mr. Grant about it too. Maybe you have some expertise in the military, and you could provide some insights with regard to how to clarify that. So that's what we're grappling with, and no one in the department really could come up with any ideas either. So we're tossing it to you to see if you have any ideas, or members of the public. Anyone would be really helpful.
If I could just comment, I think that part of the problem is that the statute says active duty, and then there's a lot of different ways you can be active duty, right? So
Right.
I think the idea behind it is that this is for people who are part-time military members who are called to active duty for some
Right.
reason,
Right.
but they can volunteer to be on active duty for any amount of time. You can be put on active duty and not deployed, and it seems like the intent behind this is for people that are deployed,
Deployed,
not just
yes.
activated.
Right.
I think that the intent is great, but the application of it is problematic because it's not, you have to define who are you going to give this waiver to and for how long. And I think also, in having read it, basically this waiver means that they cannot practice on civilians, right? They can only
No.
treat
Correct.
DOD people.
Right.
And so that introduces another complication there that maybe would not be obvious to these folks. So I wonder if it might be possible to have an internal process for this, where if someone's, like, it doesn't have to be in regulation, can we just have internal policy at the board that if someone gets called to active duty, we work with them on an individual basis? There's only about, I don't know, I think there's about 40 to 50 PAs in the California Army National Guard. I can't imagine that there's a whole lot more in the Army Reserve, the Air Force. I mean, you're talking maybe a few hundred people. And then at any one time when they may be going, if they decide that they want to delay something. When I look at this in terms of how I work as a National Guardsman, it's easier for me just to maintain my license. Like, it's way easier than to try and go through this and say, well, I don't want to pay my license fees for this 6 months while I'm gone somewhere, and then have to redo everything when I get. I just maintain it.
Right.
And, you know, it's no different than what PAs do for their credentialing at other places or anything like that. So that would be my suggestion, would that we handle this on a case-by-case basis.
Well, I think if we're going to do that, we should at least come up with some criteria in regulation, because otherwise I'm concerned that it might be considered an underground regulation if it may be difficult to do a case by case, because there may be some similarities in each case, in which situation, if you then have a common way of handling something, it's really a rule and you really need to put it out and adopt it so the public can see what those standards are. So I think maybe instead of defining what call to active duty means, I mean, we've come up with criteria for what we consider temporary assignment, maybe focused on that aspect of it. No?
Well,
You're looking
just,
at me
you
like,
know,
no.
it's like I'm reminded of the phrase that when you're in a hole, quit digging, right? So we've discovered a hole and we keep talking about how we can dig it deeper. So I don't know what the right answer is, but you know, I think we talked about just the definition of active duty from the DOD is like 15
It
pages,
is,
right?
yes.
So this is a
Uh-huh.
very complicated
Right.
definition. So
Well, why don't we, staff and I will ponder some more on it, see what we can come up with, and bring some proposal back to you at the next meeting to look at it. And we certainly need to address how we're prorating the fees and in counting, you know, if people leave at a certain point, what waiver, how much of the waiver will be credited and how that will be applied consistently, I think. Are there any other criteria that we need to address? I'm trying to remember that.
If they're going to renew, if they're still CME compliant, because their status will be either military active or military inactive. If they're military inactive, they can't practice at all, whether they're on a federal facility or not. And if they're military active, then they can only practice on federal facility.
I think we could handle that on the application. They could
Right.
just simply check whether they want to be listed as military active or military inactive.
Or
So it'll be
just
their
That
determination.
they just check that they're CME compliant automatically makes them military active.
Well,
they're usually required in order to be credentialed through the DOD to be compliant with CME. So I don't
Okay.
think that's
That's going to be
going to be
Yeah.
that big of a deal.
well, the bill requires us to waive all the requirements if they meet the call to active duty circumstances. So that's, I mean, it'll be up to them if they need to for some other body like the military to maintain it because they're going to use their license
We
while they're
just
in the
can't
military.
require it.
We just can't require them to fill out the form, send it in. So they're relieved of their responsibilities to us, not to others, to other agencies or military if they're going to be using their license.
But that's why if we could ask the CME question on the application, they can say if they're compliant or not, and that would determine their
What status they have?
Yes, ma'am.
Okay. Or, like I said, they could check the box, but
Yeah.
we'll talk that through a little more and see which one makes more sense for people. So it's, the idea is that we just make it less burdensome for the military, and that's the kind of the goal of the whole bill is to help them with those licensing requirements.
Right, okay.
I'd be happy to work with you in between meetings. if you
Great,
want.
that would be great. Thank you.
Is there a specific time frame that we currently have?
We don't have a time frame we're required to meet. It's just that this is an issue that staff had noticed there were a lot of questions on, and they wanted to help alleviate and resolve those questions consistently. And the way to do that is to adopt a rule or regulation.
Right. So my question, the reason why I asked that, I know that we're having some issues with the definitions.
Yeah.
Would it be easier just to put a time frame, leave the definitions blank, and then give a time frame for active or whatever the definition is? Can we just say, we give you X amount of time to resolve or waive?
I think the way the statute works is if they're called to active duty, they're eligible for the waiver, and then when they're not on active duty anymore, they're supposed to notify the board when they're discharged. That's the other reason the words in the statute about discharge. If you're an active military, you're not discharged until the end, right, of your service?
It depends on the status that you're in.
Okay, well, again,
Right.
it's complicated.
So that's what I'm saying, with all the complication, can we just say you have X amount of time to take care of this?
Well, it says in the statute, with its 60 days from the date of discharge, to get their status back to active, they want to practice on civilians, essentially. So they want to come back and practice in civilian life. They have 60 days from the date of discharge to meet the requirements for reinstating their license to a full active status.
Right, but we're having some issues with the definitions like discharge and all those things. Can we, I don't know, while you're thinking of those revisions, maybe it might be easier just to put a time frame on everything as opposed to, so I guess we're having issues with when it's discharged, when it's not discharged, and all the other definitions that come along with it. Maybe we can consider, and this is from a non-military person, that perhaps we can just give a time frame of that would include all of those definitions. And
What I came up with was based on when they returned. So if they returned at the end of their renewal cycle, they would just have to renew for that new cycle. So the fee would be waived for the whole time that they were gone.
Right.
If they came back in the middle of their renewal cycle to get an active license, then they would have to pay only half of the fee that's
Okay.
owed from
Okay.
from when they left.
Okay.
And if they're in between that, if they're 3/4 of the way, we just would waive the whole fee and reinstate them. So that's something that I thought the board would work with, would be able to work with if we put those kinds of,
Open-ended, I like
Yeah.
that.
Time frames.
yeah, instead of
Perfect.
saying this many days or that many days, if you're within
Right.
this time frame of your renewal cycle, this is what you'll have to pay.
Perfect. I'm
to
thinking
come
on that
active.
same line, so that's great. Thank you so
Okay.
much.
Yeah, I think what you came up with in terms of how to implement that part of it is good. The problem is with defining, who
When they're
qualifies for this.
eligible.
Yeah,
Yeah.
when are you
Yeah.
eligible? And there's just so many
That's-
different, if you add the National Guard in, they can be called to state active duty. Is that the same thing? Do we still offer it to those people? Like there's all kinds of people on active duty right now for fires,
Right.
and that's an indeterminate amount of time until the fire's put out. So there's a lot of complicated.
So
Uh,
I would have to agree with that, and I think that if our military service, they are providing a service to our state and our country, that should be it. I mean, that's enough. And I
That-
know,
Right,
I
but
know
we
from a
don't-
non-military person, I'm support of that. So I just
I agree, but I think the idea was the waiver would be temporary. So what we're concerned about is someone coming in, getting a waiver, and then for 20 years not paying
no.
a renewal
so
fee.
I think that was when
So-
Anita mentioned the time frame. So the time frames would, so anybody who fits that active, inactive, whatever service that they're in, we come down to the number of months or dates that you set forward. So we wouldn't have to get into the issue of definitions and things like that. So that's just some non-military person. Seems
I know where she's coming.
Okay.
Discuss it
All right.
further. Yeah, because we're at 9:00.
Thank you.
So
Go ahead.
Let's see if we can get another lawyer to make a good mess here. So my understanding is the definitional problem is the active duty, right? Well, doesn't this waiver only apply once they make application? And once they make application and we approve it, they are prohibited from private practice. So I'm trying to see where the problem is. If they stay on for 20 years active duty and they're prohibited from private practice, Why do we have a problem with that?
It says that you shall waive the renewal fees and other renewal requirements as determined by the board for any licensee or registrant called to active duty as a member of the U.S. Armed Forces or the California National Guard if all the following requirements are met. They have to have a current and valid active license at the time.
Right.
They have to, it's only waived for the period during which the licensee is on active duty service. So again, there's the problem of the career military, they're on active duty for their career versus someone was a civilian and they get called up and they're gone for a year and they come back.
Okay, but they have to submit, A3 says they have to submit written documentation. So if they fill out an application and say, hey, I want the waiver, then that's what we're contemplating, right?
Right.
Okay. So at that point, under subdivision B or paragraph B, it says that they are, while they're on active duty, as defined by DOD, and they give us this application, then they're prohibited from private practice.
Right, but call to active duty under the Department of Defense regulations, the one reg I could find was 15 pages long, and trying to get, this is something your staff would be implementing. So we want something that's simple and easy for people, bright line. They can say, you're called to active duty from this date to this date, so your waiver period is from this date to this date. So how do I determine that if I don't know when you're called to active duty? I have to know when the starting point is.
That's what I'm saying. So we have a PA that's in presumably private practice, right? Otherwise, why would you even bother with a waiver? Okay. So you're in private practice. Now you apply for the waiver, and you're prohibited from now private practice. Isn't that a huge incentive not to file the application unless you really need it?
It is, but I think what we're looking at is the fact that it looked like the legislature was extending it to people that were not in civilian life, that are active duty military, but for some reason, because of a change in circumstances, they're unable to renew their license online, which is what we have, a license requirement that we can do it online and we submit the fee. I mean, if there's a situation where someone's a career active military person where they couldn't do the renewal requirements.
Because they're deployed somewhere.
Yeah, like combat deployment.
Okay.
I don't know. And I'm not, like I said, I looked at those 15 pages of regulations for the Department of Defense and I went, this is not workable for a regular state employee to implement that kind of.
So in that narrow circumstance where they can't submit the waiver materials because they're in a combat zone or something.
Yes.
In that limited circumstance, can't we have part of the regulations state that upon adequate proof or whatever, that they were unable to complete because of combat deployment?
Well, that's the criteria I need from you to tell me what they are. I don't know what to say. How do I limit the scope? How should I narrow it to? Because we don't want someone to
now I understand the problem.
Be on, like I said, they're at Travis Air Force Base and they're like, I'm on active duty.
Right.
And I can't say no because we don't have a standard that says, well, it really wasn't intended for someone for 20-year waiver. So
yeah, but
anyway,
that circles us back to somebody at Travis Air Force Base that is getting a waiver.
Yes.
They can't practice privately. So
no.
What
but they're career military, so
they
they wouldn't anyway. They would be working on Department of Defense personnel.
Okay. All right. I think
so,
I understand the problem.
Yeah.
Okay. Thank you.
Thank you. So we'll take all of this back and see what we can do and see what we can come up with. Thank you for your input. I don't know if the public has any. That would be great. But apparently not.
Public comment? Okay, thank you. I'd like to take this opportunity to thank two special guests that are in our audience assisting us today. Ismail and Farah are signing people in the back of the room. And we appreciate you for being here. And also I would like to thank Officer Bradshaw, California Highway Patrol, who is sitting right outside our room providing protection for the board members today. At this time, we are required to go to the regulation hearing. The first one, item number 9. First regulation is for 1399-514. My name is Robert Sachs. I am the president of the Physician Assistant Board, and I will be presiding over this hearing. Today's date is August 10th, 2018, and this hearing is beginning at approximately 9 a.m. This is the time and place set for the Physician Assistant Board to conduct a public hearing on the proposed regulatory changes to Section 1399.514 of Title 16 of the California Code of Regulations as described in the notice published in the California Regulatory Notice on June 15, 2018. Will the Secretary please call the roll to establish for the record that a quorum of the board is present?
Charles Alexander,
Present.
Juan Amenta,
Present.
Jennifer Carlquist,
Present.
Sonia Early,
Present.
Javier Escobar Acosta,
Present.
Jet Grant,
Present.
Xavier Martinez,
Present.
Robert Sachs,
Present.
Mary Valencia.
Present.
Okay, we have a quorum established. At this time, the hearing will be open to take oral testimony and/or documentary evidence by any person interested in this regulation for the record, which is now being made by tape recorder. All oral testimony and documentary evidence will be considered by the Physician Assistant Board pursuant to the requirements of the Administrative Procedures Act before the board formally adopts the proposed amendment to this regulation and recommends changes which may evolve as a result of this hearing. If any interested person desires to provide oral testimony, it will be appreciated if he or she will stand, come forward, give his or her name and address, and if he or she represents an organization, the name of such organization, so that we will have a record of those who appear. It is the desire of the board that the record of the hearing may be clear and intelligible, and that the hearing itself may be orderly, thus providing all parties with fair and ample opportunity to be heard. Are there any questions concerning the nature of the proceedings or the procedure to be followed before we begin? Seeing none, we will proceed with the board's proposed regulation. Is there any person who would like to testify? If so, please proceed to the microphone. Don't all rush up at once. Okay. Is there anyone else who wishes to testify? Since no one else wishes to speak, the hearing is now closed. Thank you.
Do you need a motion, Bob?
Not yet.
Not yet? Okay.
Okay.
Very briefly on the background, this regulation was to allow licensees to not have to disclose minor infractions on their renewal unless they, such as moving traffic violations that don't include drugs or alcohol. So the board determined to raise the reporting requirement from $300 to $500, thus getting rid of that erroneous information that we don't use. We have received no written comments during the 45-day notice period. So I have a motion to direct staff to take all steps necessary to complete the rulemaking process, including the filing of the final rulemaking package with the Office of Administrative Law, authorize the executive officer to make any non-substantive changes to the proposed regulation, and adopt the proposed regulation as originally noticed.
So moved.
Do I have a second?
Second.
Further discussion? Public comment? Will the secretary call the roll, please?
Charles Alexander,
Aye.
Juan Amenta,
Aye.
Jennifer Carlquist,
Aye.
Sonia Early,
Aye.
Javier Escobar Acosta,
Aye.
Jet Grant,
Aye.
Xavier Martinez,
Aye.
Robert Sachs,
Aye.
Mary Valencia.
Aye.
Okay, so we will move forward with 1399-515. I'm sorry, 514. Next will be regulation retired status 1399-515. My name is Robert Sachs. I am president of the Physician Assistant Board, and I will be presiding over this hearing. Today's date is August 11th, 2018, and this hearing is beginning at approximately 9 o'clock. This is the time and place set for the Physician Assistant Board to conduct a public hearing on the proposed regulatory changes to Section 1399.515 of Title 15 of the California Code of Regulations as described in the notice published in the California Regulatory Notice on June 15, 2018. Will the Secretary please call the roll to establish for the record that a quorum of the board is present?
Charles Alexander,
Present.
Juan Armenta,
Present.
Jennifer Carlquist,
Present.
Sonia Early,
Present.
Javier Escobar Acosta,
Present.
Jed Grant,
Present.
Xavier Martinez,
Present.
Robert Sachs,
Present.
Mary Valencia.
Present.
Okay, we have a quorum established. At this time, the hearing will be open to take oral testimony and/or documentary evidence by any person interested in this regulation for the record, which is now being made by tape recorder. All oral testimony and documentary evidence will be considered by the Physician Assistant Board pursuant to the requirements of the Administrative Procedures Act before the board formally adopts the proposed amendment to this regulation or recommends changes which may evolve as a result of this hearing. If any interested person desires to provide oral testimony, it will be appreciated if he or she will stand and come forward and give his or her name and address, and if he or she represents an organization, the name of such organization so that we will have a record of those who appear. It is the desire of the board that the record of the hearing may be clear and intelligible, and that the hearing itself may be orderly, thus providing all parties with fair and ample opportunity to be heard. Are there any questions concerning the nature of the proceedings or the procedure to be followed here before we begin? If not, we will proceed to consider the board's proposed regulation. Is there any person who would like to testify? If so, please proceed to the microphone. There seeing none, is there anyone else who wishes to testify? Since no one else wishes to speak, the hearing is now closed. Anita.
We've had some comments from the Business Consumer Services and Housing Agency. They recommended that we add the words upon receipt of to subsection A of the regulation. And also our legal department has requested that we remove the line in subsection B1, shall not engage in any activity for which a license is required. The reason why we're removing that line is that it is covered in statute, so there's no need to repeat it within the regulation. These two changes, also we're changing the actual application, removing how they would become active again, as this is covered in the regulation, so it doesn't need to be repeated on the application. So this would incorporate a 15-day notice before we can move forward with the regulation. So I have a motion for staff, for board members, direct staff to take all steps necessary to complete the rulemaking process, including sending out the modified text and modified form for an additional 15-day comment period. If after the 15-day comment period, no adverse comments are received, direct staff to take all steps necessary to complete the rulemaking process, including the filing of the final rulemaking packages with OAL, authorize the executive officer to make any non-substantive changes to the proposed regulation and adopt the proposed regulation as described in the modified text notices and form.
So moved.
Second,
I second.
discussion. Do we have any idea when this would go into effect?
The 15-day notice, I'll have that filed before the end of this month. So I'm hoping to have it back. I'm looking for it to be effective either in January, with the January release of regulations, or no later than March of 2019, with an effective date. Because regulations, when they're filed with the Secretary of State, only become effective on a quarterly basis. So if I don't get it into the first quarter of 2019. It won't be until the second quarter. And I'm really looking at the second quarter in actuality, sir.
Public comment? All right, will we call the roll, please?
Charles Alexander,
Aye.
Juan Armenta,
Aye.
Jennifer Carlquist,
Aye.
Sonia Early,
Aye.
Javier Escobar Acosta,
Aye.
Jed Grant,
Aye.
Xavier Martinez,
Aye.
Robert Sachs,
Aye.
Mary Valencia.
Okay, motion carries. We will go to item number 12, regulations update discussion, possible actions. 12A.
Okay, I do have one brief update for everybody. My summary kind of, everything is current on the summary. I did hear from the Office of Administrative Law on Wednesday regarding the two regulations that we're trying to repeal, 1399.531 and 532, about approving curriculum and approved programs. Both of those have been approved by OAL and were filed with the Secretary of State on Wednesday, August 8th, and will have an effective date of October 1st of this year, 2018. So those two will be repealed, and we will no longer have to approve additional programs.
Excellent. Thank you for
Okay.
that.
Does anybody have any other questions about any of the regulations we have? Thank you.
Thank you. Okay, I guess we will go to item 13.
Yes.
Discussion and possible action regarding proposed amendments to the initial physician assistant license application, application instructions, and general information and associated initial application forms.
Has everybody had a chance to review the changes? The only really major, most of the changes were grammatical, with the exception of the initial application. We added some additional questions under the disciplinary history. We had an issue between something being charges being filed versus the outcome of those charges. So we thought we weren't as specific as we should be with our questions. So we've added questions about a license being surrendered, and we've added disciplinary actions versus administrative actions. So that's the main difference that we've added to the initial application. All the other changes are really have just been grammatical or defining a word better. So does anybody have any comments about the changes, or are they?
I would just note that you also removed the reporting by program directors of academic difficulties,
Yes.
which I think is wise.
Yes,
I like that.
because we felt that the school takes care of any academic problems. So it really shouldn't be an issue with the board because the school does handle that. So that's why we wanted to remove that.
Glad to see it.
Makes our life easier.
I'm wondering, on the first page of the application, mail completed application, check or money order, physician assistant board, and it gives our address and our suite. Could we leave the suite off since that's potentially going to change?
No.
No.
Keep it on there for now, and then we'll just have to change it.
When our address changes, do we have to get the
So we
the
go through this
application
whole
approved
process
again?
I mean, you can authorize staff to change the suite number in the future if that's something on the application, if that's the only thing that needs to be changed.
Can we authorize non-substantive changes?
Well, I'm not sure what that means exactly. The problem is the regulation requires it to be in a form approved by the board. So the board itself has to approve these changes. So if we're going to delegate authority for staff to change anything, it should be very specific, in my view.
Could we, require the staff to keep the address and phone number up to date, updated on the application.
Sure, you want to do a motion to that effect?
So moved.
I'll second.
Discussion? Public comment? Will the secretary call the roll, please?
Charles Alexander,
Aye.
Juan Armenta,
Aye.
Jennifer Carlquist,
Aye.
Sonia Early,
Aye.
Javier Escobar Acosta,
Aye.
Jed Grant,
Aye.
Xavier Martinez,
Aye.
Robert Sachs,
Aye.
Mary Valencia.
Aye.
Okay.
Now, we still need your
Right.
motion.
Motion to approve these
Yeah.
changes
I-
unless you have any concerns with any of the proposed changes.
I'll move to approve. I think they
I
look
have,
good
I
on.
have a motion for you, if you don't mind.
Sure.
Okay. To approve the proposed changes presented by staff and discussed at this meeting, and authorize staff to provide the amended forms as authorized by Title 16 California Code of Regulations, Sections 1399.506.
So moved.
Thank you.
Second.
Thank you.
Discussion? I only have one question, and it's on page 6 of 8. We're changing the term practicing as a PA to physician assistant. And I know nationally, everybody is moving the opposite way, going from physician assistant to PA. I'm looking for my vice president.
We have PA/physician assistant, can you just go over that?
Well, when I was looking at, I noticed that too, and looking at the application, it looks to me like it's just done for consistency. There's
Yes,
very,
it
like,
is.
all of the PAs were taken out. They all say
Right,
physician
right.
assistant, so
Okay.
I think you can't really put PA in there without putting physician assistant somewhere, and then, so I think it's just consistent throughout the document that that's what it's talking about. So I didn't really have any particular heartburn with it, but I did notice what you were saying.
Okay. I'm fine with it. I just wanted to bring it up so it's on the record at least.
Right.
Further
We-
discussion? Public comment? Will you call the roll, please?
Charles Alexander,
Aye.
Juan Armenta,
Aye.
Jennifer Carlquist,
Aye.
Sonia Early,
Aye.
Javier Escobar Acosta,
Aye.
Jed Grant,
Aye.
Xavier Martinez,
Aye.
Robert Sachs,
Aye.
Mary Valencia.
Aye.
I'm done.
Okay. Wow. Where'd the morning go? Why don't we take a 10-minute break, and then the board will go into closed session pursuant to section 11126C-3 California Government Code to deliberate and take action on disciplinary matters. So we will come back into closed section at 9:35. Thank you.
Yeah.
To order. So we will go to item 15, Education Workforce Development Advisory Committee. Mr. Grant and Dr. Alexander.
Mr. Grant?
Yeah. You have in front of you the subcommittee report on sort of what's going on in California with the development of new PA programs. So there are about 234, this is as of about a month ago when I checked all the websites on all this, 234 PA programs in the United States, and 15 of those are in California, with 4 more in development in California. And you can sort of see the distribution by color. The LA and San Diego area has 12 programs, with most of the new developing. There's 3 new programs that came up since our last meeting, and they're all in the San Diego area. 5 in the Bay Area and 2 in the Sacramento and Central Valley. So 4 programs. If you look At the current annual capacity of PA programs in California, 671 seats, and those are potential graduates every year. We can assume that most of those would be licensed in California, although some people will go out of state. And then when the new programs that are currently developing, the 4 programs come on board, a couple of the programs didn't list how many seats they're planning on, but if we use the average number of seats per program as 44, we sort of assume that they're going to be around that number. That gives us about 878 people graduating from PA programs in California every year. It's important to note there was a study done last year where they looked at how many applicants geographically come from an area versus how many programs are in the area that they come from. So California has the highest number of applicants to PA programs of all the states in the United States. The majority of the applicants, the most applicants come from here. However, we have the lowest number of seats to applicants. And so what that means is we're likely to see continued growth of PA programs. And looking at our numbers of applicants per year, it's about double. So however many graduates we have in California, we get about double the number of applications for licensure, if I understand correctly, from outside the state. So looking at this and sort of projecting the number of licensees that we're likely to have in the next few years, and board staff and all of the connected issues that come along with higher numbers of licensees, we can sort of predict what kind of workload we're going to have to make sure that the public is well protected. So that's pretty much it. I do note that CSU Monterey Bay, it says developing on your paperwork, but I got an email a couple of days ago, so they have received their provisional accreditation. So they'll probably be seating a class within the next year or so, which is great.
So Jay, can I just ask a question? So in total, we have about, say, almost 900 students in the programs, but you're saying we anticipate double the amount, so 900 coming into California, so a total of 1,800 new applicants a year.
Once within the next few years,
Within
when
the
all
next-
these programs are spun
Right.
up, that's correct.
Okay, all right.
It's an approximation, but
Right, that's good to know.
certainly can see an upward trend
Right.
on the number of
Right.
licenses being issued, and then we know, there's a small percentage of those people that are going to
Right.
need some extra attention from the board.
Exactly.
And so if you look at workload, not just for licensing, but maintenance of licensure, enforcement, all of those things,
Right.
we can anticipate we're going to need more space and more staff.
Are we the state that has the highest number of PA programs living in the United States?
No, we do have the highest number of applicants, but there are
Okay.
states, very high concentration of PA programs on the eastern part of the United
Right.
States.
Okay,
So,
thank you.
Jen, is AT, I never heard of this school. Is
AT Steel?
AT still?
Yale University, is that the only one in San Diego? Or is it-
There's 3 programs developing in San Diego.
So Point Loma,
Yeah, Point Loma. I think St. Augustine is in San Diego as well.
okay.
Just a comment on what you were saying about schools that are outside of California. As an example, not quite, I think Duke's, this semester's graduating class from Duke was 38 students, and we had 15 applicants from those 38 coming to California. Just as an example, you were saying how many would come into California outside, going to schools outside, and Duke is a perfect example of that.
Yeah, great, thank you.
Other things we need to include is that people who want to go in the PA profession were heavily sought out, and they will go to school anywhere to get that license and then come back home.
Yes.
So we could have a lot of California students in other locations, and they're just coming back home. So.
The benefit of them training in California is that, they become familiar with California law, and the board does good outreach to PA programs while they're in school here to kind of teach them, how our laws work. And so out-of-state applicants may not have that benefit. So, any other questions? Yeah.
Well, I know somebody who's going out of state because of cost,
Mm-hmm.
and that's one factor.
So previously on this report, I included the cost of the various programs. It's around 105 or so for the average cost, 105,000, but there are some that are well over 200 and some that are well under 100. So it depends.
Further discussion? Public comment? There being none? Thank you, Jed. And Dr. Alexander, we will go to item number 15, Budget Subcommittee Update. Xavier, you get to tell them about our meeting.
Well, it was a very good meeting, very informative. We learned a lot about the budget process. One of the main things I learned, and I think Lynn learned, was that the executive officer could be on the hook if we go into the red, and including the board members. But I asked Lynn to ask Christy to look into the section that discusses that, and Christy said that we'd have to actually know that we're going into the red before we would be subject. But it is in the law. So I don't know if you all knew that when you signed up, but
Well, they start with the newest member, right?
That'd be the shortest tenure you've seen.
But that goes back, and I asked Christy to
Well, it's Section 32 of the Budget Act every year includes a provision that says no officer of any board or department or agency can spend money in excess of the appropriation they've been given, and you're all officers. An office is created by statute, and the positions in your Physician Assistant Practice Act are executive officer and board member. Those are the two offices in your act, and so you're responsible for staying within your appropriation. And then, it says that you cannot create an indebtedness in excess of the appropriation. And the way you create indebtedness is that your employee, you've delegated the responsibility of managing your budget. She brings you a copy of the budget every meeting. You have the information in front of you. If you see that you're going into the red in any situation, you should be directing your executive officer to stop spending money. So that's the goal. Whenever we bring the budget information to you at the meeting, is that you stay informed. And your president, I know she keeps your president fully informed about where we are on these issues. And so you have a good working relationship. But it's a rule of reasonableness. If you don't have all the information in front of you, that's not your fault. I don't know how you'd be legally responsible for spending beyond an appropriation because you didn't know you were spending beyond the appropriation. So I just wanted to make sure that you're comfortable with the fact that as long as you're involved and you have been presented information that's accurate, you can rely on it, then I don't see there being an issue for you because it is a rule of reasonableness. And it's basically based on I'm sure you've heard of vicarious liability. Your officers, your employee, just to make sure your employees spend within the authority. And that's your job, is to observe and watch and manage them in the function of expending the money. And that's why you get the budget every meeting, is so you're informed about that information. Any questions about that issue?
What's the enforcement mechanism? Suppose we had a budget in front of us and decided to spend $5 million on some ridiculous endeavor. What would be the enforcement mechanism? It's the state, right? The AG?
Yeah. I mean, I've only seen one situation where they were going to go into the red, and the letter went out from the budget office notifying the board and the executive officer that they would be held personally liable if they did. And the executive officer resigned and the board didn't spend the money. So it never actually went to the point of enforcement. So the job of one of the reasons you pay pro rata the budget office department is so that they can keep you informed. But if they're hampered by the fact that your computer program that the state has entered into doesn't give them all the information, again, I don't see how there would be liability for you in that regard, because it's a rule of reasonableness. And so, but just be aware, keep on top of that when things do get corrected, hopefully soon. Make sure you're keeping your eye on that. And I know maybe Mr. Sachs can speak to those years when you've had to stop spending on certain line items, because where you tend to spend money is your litigation and attorney general line item. because you don't have a lot of control over how long things litigate, how much, something's investigated, may have to go beyond the time you thought it would take. So costs may run up beyond what you projected. It happens. In that case, there's a variety of mechanisms for correcting. One is stop spending the money, another is getting a budget change proposal through, another is redirecting funds within your budget. There's a lot of things that can be done, but that's the job of the budget office, is to assist your executive officer in resolving those issues for you.
Thank you.
You're welcome.
And that goes to what we learned about Fiscal. Fiscal is the new accounting system, and they're behind on that. We have period 11, so we're looking at period 11, trying to decide, if we are overspending or not, and we don't have all the facts yet. And they discuss that they're working on it, but we always hear that we're working on it. The other thing I learned, which I wasn't aware of, is that there's 3 budgets that are still open: 15-16, 16-17, and 17-18. So I was coming from the public sector. When you close the books, you close the books. But in this case, you still have budgets that are still open, because things could, my understanding, things could come in that apply to those years, and they don't want to close them yet. So that was something else that I learned. I think there was a lot to learn, but it just...
Well, with that being said, can we ask for retroactive increases if we still have open books from 15, 16, 16, 17, 17, 18? Can we retroactively ask for?
I don't think you can. I think it's for items that, let's say, a vendor forgot to send the bill in and it applied to that 15, 16 year, and he does, and they apply it to that year.
And then also, Christy also mentioned, and we've done this in the past where we ask for increases. Can we ask for increases? Is there a point in time? Can we ask for an increase every year or is there some?
There's a process to ask for
Right.
increases.
And have we asked this year?
Yep,
we
yes.
received
We have? Okay.
Yes.
Okay.
We already have a BCP in for next year.
Okay.
Right.
Okay, perfect. All right, thank you.
And the funds that Bob keeps on asking about are there. They just don't show it for some reason.
Wow.
So,
And I think one of the things we did find out was the money, if I understood it correct, the money that comes back from disciplinary cost recovery goes back in to our actual working budget. It was a line item that I had never realized that's what that line item was. And they explained that to us in the meeting, which was very helpful. Because we thought it was just going into the fund, which we couldn't touch, and yet we're spending it. At least it should be coming back into the budget, and I thought, so that helps a little. It was a good meeting.
well, that was another item they brought up about each line item. They look at it separately. So if you overspend in one line item, that could be an issue. So,
So at what point do we close the books? I'm just curious. This would go back to 2009 if somebody does.
no,
or is there
15, 16, 17,
3 years.
3 years.
16,
3 years,
17,
okay.
17, 18. It was 3 years.
Okay. We've got 3 years.
So when we go 18, 19, then we'll
Right.
close 15, 16.
Okay.
Any questions? Because I still have a lot and I haven't learned it.
Thank you.
Okay.
Appreciate the report. Public comment? There being none. Budget update from the budget analysts. They're not here.
They did provide month 11 expenditures, and if you look at it right now, we're at 1.5% to the good as far as our budget. If you look at the line items, we are extremely frugal in the office. We don't go out and just spend money unnecessarily. But our big line items are Office of Administrative Hearings, the Attorney General fees, and our investigative fees. Those are our big line items. We did receive the augmentation this year for the AG, so we will be moving forward with that again probably next year as well.
I like the fact that we are cost efficient. However, I think when Jed mentioned that we've already doubled, in the last 2 years, we've already doubled our PA capacity. Are we looking into more staffing? Because we're tripling our,
We are looking at more staff. I hope to be able to hire some new employees at the beginning of next fiscal year. Our licensing technician is part-time. We are trying to get her to go full-time because of the increased applications. And we're looking at hiring a few more staff because of the increase with everything.
great. All right, great, thank you.
Some of that is in the ECP that,
Yes. Yes, exactly.
okay. Public comment? All right, we will go on to item number 18, report of the legislative committee, discussion and possible action. Mary and Sonia.
Okay, thank you. Before we get started, I just want to make a little statement and note that the agenda actually lists all the bills we had ID'd and discussed during our April meeting. However, today I'm only going to discuss in detail those items we have placed on the watch list that we wanted to watch. So if anyone has any comments on any of the bills listed on the agenda, the full list, then I ask that you please wait until it's public comment period, and we'll take them then. So basically, we have 7 bills that we'll discuss in a little detail that we had on the watch list. And most of them have actually ended up in the suspense file, meaning they're dead. So AB 1998, dealing with opioids, prescription limitations, was placed on suspense file and most likely dead. AB 2078, sex offenses, professional services, was placed on the suspense file and will most likely be dead. AB 2143, mental health licensed service provider education program, passed out of the appropriations committee, and it's being held for a 3rd reading, so it hasn't moved to the floor yet. So that one is still in movement. And that was a watch, so we'll continue to watch that one. 2483, Department of Consumer Affairs, Office of Supervision of Occupational Boards. It was another one we were supposed to continue watching, and that bill is now dead. AB 2741, prescription drugs, opioid medications, minors. That bill is also dead. SB 1298, the Increasing Access to Employment Act, has been put in the suspense file and will most likely die. Now, the last bill that I really want to pay specific focus to is AB 2138, and that was the licensing board denial of applications relating to criminal convictions. This is the one that we really discussed in detail in April, and we chose to oppose and really engage in as the conversations were happening and amendments were being taken. The author is contemplating still taking some additional amendments. Conversations are still happening. So we, based on our legal counsel here, has advised us to consider appointing either the chair, the vice chair, or the ledge committee, which would be myself or Sonia, to possibly stay engaged with our executive officer here and to discuss possible amendments that might make this a little more palpable for the board itself. I'd like to ask Christy if she wants to add any additional. I know she kind of mentioned this earlier, maybe talk about it more in detail, because it could be a real issue if this passes the way it is.
Okay, so Assembly Bill 2138 proposes to essentially create a standard whereby if you weren't convicted of a serious crime, which is kind of unclear where that's defined. It says serious felony crime is set forth in the penal code. I'm not sure which part of the penal code they're referring to, but that is one thing we would need clarification on. But essentially, I would believe it would be things like rape, robbery, murder, mayhem, arson, what's considered violent crimes. Unless you were convicted of one of those, it sets up a presumption that you're rehabilitated after 7 years after you were convicted. The problem with that is that current law, we don't have any such presumptions. We're allowed to look at the conviction no matter when it occurred, and irrespective of whether you received were granted a motion to set aside your conviction, we still are able to look at it. Under this bill, you would not be able to look at any crime that had been set aside because you were successful in getting it set aside pursuant to a penal code provision that allows that if you've completed all your probation, your criminal probation. So it would significantly narrow the board's ability to look at actions that may affect public safety in determining whether someone should get a license. So, this is something that's been a policy that certain groups have been pursuing, and it looks like this bill maybe will go through. And so the question is whether you want to authorize a board member, and it would have to be a single board member, to continue to negotiate possible amendments and potentially change your position on this bill. Right now, it's straight up oppose. But the value in maybe delegating to one person the ability to negotiate is that you would be able to maybe make some significant inroads to addressing some significant public safety concerns. One of the concerns is the bill amendments as they currently stand basically don't allow the board to examine a conviction if it's 7 years from the date of conviction. Well, current case law, we look at rehabilitation as the time frame from which you're released from the command of the criminal justice system, meaning you're off parole, off probation, not incarcerated, not subject to any further criminal court order, because that's when you can truly tell whether someone is internally rehabilitated and will not reoffend. So that's the case law in this area right now. So one of the amendments that I would suggest seeking is it should be 7 years from the date of release from prison, probation, or parole. Not 7 years from the date of conviction, because they could be convicted of racketeering and corruption and be in prison for 10 years and get out and get a free and clear license with no restriction, because it's been more than 7 years since they were convicted. So that's one issue. Another is some of the boards have discussed allowing or suggesting to the legislature that they amend the bill so that you can define what other crimes should not be subject to the 7-year washout period. Because what the crimes that they've put in here only have to do with physical harm. Sometimes there's other kinds of harm like financial or fraud that you are concerned about, because dishonest acts really do affect the ability to protect the public. If you're got someone that's committed fraud against a patient and you're not able to deny them a license because it's been more than 7 years, or even consider placing them on probation because you want to monitor them to see if they're truly rehabilitated, then this legislation, if it goes through, would not allow you to look at those types of crimes after 7 years from the date of conviction. So some of the boards have suggested, well, could you put in the bill that it's 7 years for any crimes that are not serious, or any crimes, that are defined by board regulation. So at least you could come up with the list of crimes that you consider not subject to the washout period, because historically it has been proven to your professional judgment that this is a crime that would seriously impact the practice of medicine. So that's one amendment that some of the boards have talked about. Another is if there is this need to do regulations, authorizing this board to do emergency regulations so that you can get this standards up and running as soon as possible. Because if the goal of the bill is to license more people and to remove barriers to licensure, then this will take much longer for you to do if you don't have the ability to set those standards quickly. So that might be something you want to ask for. Another is the bill would strike our ability to ask whether someone's got a criminal conviction on the application. So we wouldn't be able to ask people if they have criminal convictions. And as you know, sometimes we don't get all the information from the rap sheet because out of states, people in other agencies in other states may not be as consistent in reporting to the FBI the convictions that they have. And so we've had situations where staff have received information on the application form that they did not get on the rap sheet. So that's a real concern if you can't ask that question on the form. So And in addition, how do you analyze someone's rehabilitation? What if somebody wants to submit information, because you do have information on the rap sheet, and you can't talk to them about the bill would prohibit you from talking to them about it and requiring them to submit any information. So how do you even evaluate whether to deny the license or not if you can't even speak to the applicant who has the source of information that you need about their crime and whether they've done anything to become more rehabilitated? So one of the other options was to authorize the board to allow the applicant to voluntarily submit information relative to their criminal history so that you can evaluate whether to deny the license or not. Because what may happen is people just have the rap sheet and not much else and may have to do independent investigation, which would take longer to process that application in one instance. Another instance, they may be outright denied because they don't have any evidence of rehabilitation. Which, again, the goal of the bill is to remove barriers, and this may actually create more barriers to licensure. So one of the things the boards have talked about is authorizing the boards to request information but not require it. If the applicant wants to submit information, they shouldn't be prohibited from submitting it as part of their application. The other thing this bill does is it strikes 2 or 3 different criteria from Section 480. So let me show you where that is in the bill. May not show on this copy. Yeah, it doesn't show. But the current law is that you may deny a license based on 3 different criteria. One is they've been convicted of substantially related criminal conviction. Okay, so this bill deals a lot with that aspect of denial. Another one is done any act of dishonesty. So they struck that authority in this bill. So if they lie to you for any other reason, and it's not just that they had a fraud conviction, they flat out lie to you about their credentials, what happened to them while they were in school, anything else relating to the case, you wouldn't be able to use that as part of your denial of their application. So, dishonesty has always been a basis for denying a license application because it goes to the heart of whether you're able to practice safely to the public. Another one is if you've done an act where if it were a licensee, they would be disciplined for it. They struck that authority as well. So essentially, they've only left you with one basis for denial, which is a criminal conviction. So what I would suggest is maybe seeking an amendment to restore those and maybe limit it to other cases besides criminal convictions. So if you get any other grounds for denial in it, that come across your desk, and the licensing staff may be able to speak to that more than I would because they see this more than I do. You might want to seek an amendment to restore that authority because I think that would seriously hamper your ability to process applications for the safety of the public. So those are the kinds of amendments I would suggest seeking. I think it's your call whether you want to delegate any authority. And the reason you delegate authority is because we don't have enough time between now and the end of the legislative session. And I think that the bill is going to be moving to the Senate floor in another week. That's my understanding.
It's in the suspense file now, yeah, but.
I've heard it's going to the Senate floor
Yeah,
next.
they take up the amendments and they move it, yeah.
So,
That's where it goes next.
Can I ask a quick question?
yes.
So this seems like it's now an expungement, and then we talked about definitions, so now it's not set aside anymore. This sounds like now these.
Well, no, it's not erased from your criminal record. They're just saying, state, you cannot use it anymore.
And then felony versus
Doesn't
criminal
matter.
versus, we mentioned criminal, I know this one's talking about felonies, serious felonies, and then do we have definition? So anything, no misdemeanors? Or-
If it's a serious felony, then there's no washout period, meaning we can use it unrestricted. If it's like
do we have a
murder,
definition
mayhem.
of serious
No,
felony?
I've found provisions in the penal code that I think they're talking about, but again, that's another legislative amendment you probably want to pursue. It's like I think it may be referring to a penal code provision in the 11900s that lists what a serious felony is. I think it's 1192.7 or something like that, but I'm not sure. So we would really need that clarification, I believe, to adequately administer the statute.
Right.
But again, these are one of several issues that I felt I wanted to bring to your attention in case you're interested in seeking these types of amendments. And because we don't have a lot of time to have another board meeting, one thing you could do is delegate it to one of the officers to negotiate these and work with staff to seek amendments to address these concerns.
And if this passed, would this change our application license?
Yes.
Yes.
So all the questions on convictions would have to come off.
So we can't even inquire as to criminal history
No.
under this bill.
No, we can't.
I have a
This
question.
is absurd. What would even motivate someone to put this in?
Well, it's called this ban the box thing. If you recall years ago, they removed the question from state employment applications. I think it was 4 or 5 years ago. So the state, when you're applying for a job with the state, they cannot ask on the application if you've had a criminal conviction.
How does this benefit the consumers that are treated by physician assistants?
Well, I don't know that it does. I mean, that there's a policy goal here. If you look at who's supportive of this bill and who sought this bill, it's to remove barriers to licensure. If you recall the Little Hoover Commission report years ago about barriers to licensure, one of them was criminal convictions that they mentioned in their study. So that's why I'm saying you watch these Little Hoover Commission reports, because legislation will frequently come out of those reports. And this whole North Carolina dental board examiner case where they claimed that, board members were not serving the public, but actually trying to keep out competition from the marketplace. So it's now shifted in all these years to focus on removing barriers to licensure. Yes.
So it's passed out of the assembly. So that's,
No, it's
It's
out
passed
of
out of
Assembly, it
Assembly.
went to Senate, it was being held, it's on a suspense because they're taking more amendments possibly, then to the Senate floor, then back to Assembly for concurrence.
so the
But our
the
deadline
session's
started-
over at the end of the month,
Yeah,
right?
April,
August
So
31st.
what's the feeling that it may go all the way and get,
That's what we're hearing, that it will go to the
Yeah.
governor's desk.
Could we assign, you said, an officer to be on task for this for the rest of the month to navigate on our behalf?
Yes, that's what I was suggesting, so that you have the ability to negotiate with the author's office outside of a noticed board meeting. It has to be one, because if you have two and it's a multi-member body, the Open Meeting Act requires you to notice that meeting. So
make a
if you
motion?
delegate it to one person, I don't know if it could be the president, the vice president, or the ledge committee chair, whoever's maybe interested in maybe working on this issue. Anyone?
If I may, so the problem with this looks like, just from a legislative program, they captured every board, right? So the contractor
board.
state
Yeah.
license
Every board,
board,
yeah.
the dog
Medical
catcher
board.
board,
Yes,
if we have one of
yes.
those, and didn't really focus on public health so what is the
Well-
medical board doing with this?
Well, they opposed it as well. They were in the meeting with us. We attended a meeting with the staff for the assembly member that sponsored this bill. And they were there. We argued all the points that the board asked us to argue at that meeting. And basically the response was, this is a new policy shift for the state, and we're going to be focusing on getting people jobs who have criminal convictions, because we feel like that, the historical way the boards have handled convictions has been unfair and barriers to people becoming reintegrated into society. So it's a policy
Yeah.
position, and so you can argue all the public health and safety, and you can
Right.
say that if you look at our stats, it's less than 2% that are ever outright denied. Everybody else gets a license. It doesn't seem to
Right.
it doesn't seem to have any traction, even though that's consistent with all the other boards in the department. It's a small percentage of the population that gets outright denied, and it's because the crimes are quite serious. So,
I'd like to make a motion, but my question before I make the motion is who's best suited
that's what
to
I'm
represent
asking,
it?
for what you
And
feel.
interested.
Who's interested in working on this is my question too.
I'm happy to work on it. Mary, if you're,
I'm more than happy because this is.
Well, who's in,
Okay, well, it's gotta be
who's in
one.
Sacramento?
But
Who's
I
in
think
Sacramento
he's
the
closer
most?
up north than I
Yeah.
am, that's the only thing.
Okay.
So
So
maybe he
Mr.
should.
Grant, so, the motion could be to consider authorizing the vice president to work with staff in negotiating amendments to this bill and authorize the board member, the vice president, to consider changing the board's position on the bill if the amendments are accepted.
Can I say so moved, or do I have to
Yeah.
repeat it? So moved.
Second.
Second. Oh,
Further discussion?
So
And-
just real quick, so did the board members agree with some of the suggested amendments? Do you think that would be consistent with your position? These amendments that I
No, I-
discussed?
Yeah,
I
I
do.
think there are,
I
do.
yeah, I think we brought it.
Okay.
Now, can Jed discuss with Mary what he's doing?
No, he really should keep it to just the staff, because if you have meetings with more than two, with two or more, then you're kind of
I thought
going
it was
down.
3.
Yeah, I
board
thought it,
members.
Yeah,
Well, it's a quorum of any committee, so you only have a two-person committee, right?
Yeah.
So you have one person committee discussing.
maybe we should appoint someone else to that committee. Then it's a three-person committee.
I
Then it
would
would
just
have to be
suggest keeping
agendas.
it, I would suggest keeping it to just one to avoid a potential argument of an open meeting act violation.
So if
Jed
I'm,
could communicate to the executive officer, and the executive officer could communicate to Mary.
You're not allowed to do a serial meeting through other people, other means. So if it's on the same subject and it's communicating what Jed thought to, like playing telephone, then no.
don't worry about it, just go in there and do what you need to do. Don't tell me anything.
Well, that's the idea, is that you're delegating to one person. You trust their judgment. You trust that they're going to advance the board's position and make those arguments and make the call. That's the idea behind delegating to one person.
we only have like a
Xavier.
couple weeks anyway.
Yeah, it's gonna be
time is
very
short.
quick.
And those
Yeah.
were your 5 bullet points on
I have it
potential
on
amendments.
this spreadsheet right
Right.
here. Right.
Okay.
So can Mr. Grant discuss it with the executive officer?
The DCA exec?
Yeah.
Sure, yeah. They're not board members, so that's
Okay.
no problem there. Yeah.
Or with Lynn. We
Yes.
can discuss it with Lynn, yeah.
Yeah, she's not a board member.
Okay.
Right.
Further discussion? Will you call the roll, please?
Charles Alexander,
Aye.
Juan Armenta,
Aye.
Jennifer Carlquist,
Aye.
Sonia Early,
Aye.
Javier Escobar Acosta,
Aye.
Jed Grant,
aye.
Xavier Martinez,
Aye.
Robert Sachs,
Aye.
Mary Valencia.
Aye.
Okay, motion passes.
Anything else? Public, it was public comment.
Public comment?
I have one thing to add, please. An additional bill was brought up to us by our DCA ledge staff. It's SB 1338. It authorizes a physician assistant to certify additional energy allowances that are necessary under electric and natural gas medical baseline programs for those with life-threatening medical conditions who are on life support. So he just brought it to our attention. I'll put it on the watch list. But it was up for a hearing. I think it's been sent to the suspense file, so. But that's for the next agenda.
Okay. Further things from Ledge Committee? Is that it?
It was a very busy year, that's it. That's all I have to say. We had a lot of bills this year.
Thank you both for all your efforts, appreciate it. Okay, moving on to item, do we need to discuss 2-year bills, or did we?
No, one of them was the one I mentioned. It's already
Okay,
been,
238,
it's been done,
2138,
yeah.
okay. Item number 20, discussion of PA Board strategic plan. And then we'll go back to 19. this would be to accept the document that we produced in April, I believe. My only thing is, in rereading the statements that I make, the board is continuing the creation of the BREEZE program. Are we still creating BREEZE?
We're updating.
Okay.
Yeah, it's updating more so than creating
Do we want to put in about creating a real fiscal program?
anymore.
Talk to the legislators.
Okay. We need to have a motion.
To accept.
I'll make the motion to accept the strategic plan.
Okay. Do we have a second? Okay, further discussion? You will have to live with this until 2023. Public comment?
Oh, I had a question.
Yes.
Is this gonna survive the audit? Like the last one did?
I would hope so. I mean, you know, we produced, the last one was solid and it was not acceptable to the audit.
All right.
Yeah,
Yeah.
we got dinged on it.
We got dinged.
Oh, no, for what?
It
Didn't
wasn't,
have
It wasn't robust enough.
benchmark.
yeah,
So
You could say it wasn't solid enough.
I guess it's still at risk for that.
I think we were a little more specific in some of the
Yeah.
things that we came up with this year, which will be easier to benchmark, so.
All those in favor, or further comment,
Charles?
public comment? Will you please call the roll?
Charles Alexander,
Aye.
Juan Armenta,
Aye.
Jennifer Carlquist,
Aye.
Sonia Early,
Aye.
Javier Escobar Acosta,
Aye.
Jet Grant,
Aye.
Xavier Martinez,
Aye.
Robert Sachs,
Aye.
Mary Valencia.
We did
Aye.
all those votes with my report there.
next time's fine.
Okay, so the motion passes. We have a new strategic plan. Let's go to item number 19. Agenda items for the next meeting. OTP, elections, fiscal. By then, we should have month 13, sort of.
We should, yes.
Yeah. The two bills that we're continuing to work on, the one AB 2138, the one that Jet's gonna work on, and also that SB 1338. Those will be the two items only. We don't need to list everything else again.
Do you want to keep 2143 on there? That's the one where our license gets an extra fee to pay for mental health things. We're just watching it, but
I had,
Oh, go ahead. Go ahead.
well, I noticed they changed the language from the board charging the fee to the provider group charging the fee. So do you know anything about that? You don't? Because the language that was, you objected to the last time said that the board would charge $20 to provide the fee. And the bill has been amended, to require the provider group to provide the fee. So I didn't understand that amendment,
Who's
but I
that?
thought you did because you kind of blew past it. So I was like, all right.
Uh,
So
I don't know what is the provider, does it define provider group?
it's the health provider group that they're in, whatever group they're in. So it says on page 4 of AB 2143, right?
Yeah.
The program shall keep the fees from the different licensed providers separate to ensure that all grants are funded by these fees collected from the corresponding licensed provider groups. A grant recipient, who is a person described in subparagraph B, which includes you,
shall have his or her grant funded by the fees collected from the corresponding licensed provider group described in subparagraph A, of which he or she is a licensee. So I don't know what a corresponding licensed provider group means. Does that mean the board, or does that mean some other group? Do you?
I thought that meant like, you know how they work when they're in the facility, they're groups.
That's
We
what
can
I
ask
thought.
Brian to clarify that for
I
us.
think
Maybe
you
we'll add
should.
that too. Okay, AB 2143, we need more clarification. I'll look into that one.
Thank you.
And that's still in Senate appropriations, it hasn't moved to the floor yet. And then, of course, has to come back to Assembly for concurrence.
Do you want to ask if they're looking at the that option, or do you want to postpone that for another meeting?
I can hear you, I'm sorry.
Military waiver, do you want to add that to next meeting or postpone it until the February meeting?
I think we should have
I think we
an
should-
update.
I think so
next
too.
meeting at least,
All right.
of all of the regulations that are pending. And do we need to revisit the application also?
Well, we'll need to revisit it if the bill goes through, because you're gonna have to strike all the conviction questions if it goes through as written.
Okay, but even without that, if we accept the application?
Yes.
Yes.
Okay. And budget update from Department of Finance.
Yes.
Workforce committee, I think
I don't think so.
we have to do our score voting, you know, that, where we have to approve the.
I thought we,
score.
And it'll be on the agenda, the standard year-end stuff will be there.
I might want to put back on the North Carolina update. There's been some legislation that's been proposed to indemnify board members and relieve them from liability if there are antitrust damage awards at the congressional level. So I might want to discuss that and talk about where that is in the process.
I've got it down.
Sounds good. Anything else? Once again, what we decide today on the next agenda is just a start. Any board member can contact Lynn to say, I want to add this to the agenda.
Can I ask one more thing before we close? I'm not sure, I know we're moving towards the end of the year. Do we need to discuss, like, one meeting? I know we have it in San Diego. Do we need to do that at that next meeting?
It'll
Yeah.
be,
It'll be included in there?
it'll be the meeting dates and locations will be on the last agenda, yes.
Okay.
Do we have another meeting, no, January, when is it?
November.
Our next meeting is
November 5th.
November 5th in Sacramento, which is a Monday. Other things? All right.
Before election.
I have
Thank
one-
you,
it's not on
everyone,
the
for your
agenda.
attendance.
Not
Yes,
on the agenda, but will we know if we're reappointed by November 5th?
Good point.
I would hope so, yes.
Okay.
that's helpful.
Yeah.
okay. Anything else? Thank you, everyone, for attending.
Thank you.
Thank you.
Thank you.
We will adjourn the position assistant board meeting.
30.
Awesome.
Nice.
Great.